Okay, hello. So as you know, I've gotten a little bit behind the schedule. And so to catch up, I've decided to break the next lecture into two lectures. And this, which I'm going to call lecture 6.5, which will be quite a short lecture, I hope no more than about 15 minutes, will finish up my remarks on Hobbes, and then I'll start afresh with lecture 7 on Locke. But together, lecture 6.5 and 7 will, I hope, add up to about 50 minutes, so I'm not adding any time. I just thought it would make sense to complete my remarks on Hobbes in a separate lecture, and then you can start afresh on Locke with a different lecture. Okay, so I was talking about Hobbes's negative conception of freedom in the last lecture, and you'll remember that I canvassed a number of direct objections to the negative conception of political freedom that Hobbes offers. And I discussed one of these, namely the objection that Hobbes's negative understanding of freedom is too thin. And I offered a number of reasons for thinking that even if he doesn't have a concept of positive liberty, a notion of liberty as self-determination, it doesn't follow that autonomy, being master of one's own destiny, these values of freedom, that they wouldn't receive some protection under Hobbes's state. So I gave a kind of response to the first objection. Might not be a decisive response, but I hope it's worth your while thinking about it. But I want to say a little bit about the other two objections as well, and then make some more general remarks about Hobbes's views about freedom, and ultimately offer a very strong criticism of his view, and raise some further questions. The two other objections that are outstanding, one was this neo-Roman civic republican objection that says that as long as the state retains the right to take away and withdraw citizens' negative freedoms, then it isn't really the case that citizens are free. They're rather in a slave state, constantly at the mercy of the sovereign, who at any moment might take away any freedoms that they currently enjoy. And then the third objection had to do with freedom of religion, freedom of thought, freedom of speech. And I'll say just a little bit about each of these last two objections before making some other remarks about Hobbes on freedom. So what of the civic republican objection? Well, I think there are a couple of Hobbesian replies that are worth considering. By the way, I'm not trying here to argue that any of these responses are decisive. I just want to show you what the arguments on both sides are, and then you can, take the arguments in your own direction, reflect on whether you think any of these replies have merit. You may conclude that they do, you may conclude that they don't, but at least you'll have some understanding of how the dialectic goes, how the arguments on both sides line up against each other. One reply that I think Hobbes might make to this neo-Roman civic republican objection is to say, well, it's not really true that citizens are enslaved to my sovereign, because slavery implies that one is being constantly made to do something against one's will. But of course, if my argument works, and that may be a big if, but if it works, then Hobbes is in a position to say that the state is what rational beings voluntarily will for themselves, because they will their own security. And if Hobbes is right that the only form of political structure that's going to get us out of the self-destructive state of nature is a social agreement with the structure of his social contract, then Hobbes is in a position to say that my argument isn't one that puts citizens in a position of slavery, because my argument can show, Hobbes might say, that actually we all voluntarily agree at some level, or we can presume that rational beings would voluntarily agree to subject themselves to the sovereign in the way that he argues. That response may not carry a huge amount of weight, but perhaps it's worth considering. A second response is to say, against the civic republicans and the neo-Romans, that their argument, their objection, rests on a kind of utopian fantasy, namely that human beings could ever be in a situation in which they are entirely free of any risk that the sovereign states that rule them will never take their freedoms away. There's no way you're ever going to have that absolute guarantee. It's always going to be the case that our liberties are, in some sense, at the mercy of the sovereign, and we have to get used to that. It's not feasible to imagine some guarantee that under all political and historical circumstances, citizens' freedoms will never be menaced by state power. Again, perhaps not a completely decisive objection, but certainly one that is worth thinking about. And a third possible Hobbesian reply goes back to something I was talking about in the last lecture. You'll remember that I was keen to stress that although Hobbes insists that the sovereign is unlimited, his view can make room for the idea that government agencies can be limited and can limit and check each other according to some constitutional arrangement that the sovereign itself wills. And so since checks on governmental power, court oversight, judicial review, for example, can be reconciled with Hobbes's view, then maybe a large part of the civic republican objection, which after all appeals to various kinds of checks and balances to protect individuals' freedoms, maybe he can actually accommodate a large part of the civic republican objection. And of course also notice that on Hobbes's account, these checks and balances are going to actually have teeth in his view, because if the sovereign has willed a constitution in which some branches of government are permitted to check others, then it's going to follow that that settlement is going to be backed up by force, right? So if Congress chooses to defy the judicial branch and refuses to leave the building because the court has struck down some piece of its legislation, then the sovereign can move in and empty the chamber and ensure that the judicial branch gets its way in this case. Physical force can be applied by the sovereign to ensure that the checks and balances that are built into a constitution that the sovereign itself ratifies are actually operative. So you might think that it's not quite so clear that Hobbes's position and the civic republican position are completely at odds. That might be a basis for a rapprochement between the two views. What about freedom of thought, speech, and religion? Unsurprisingly, this has been a major point of contention, and many people find it very, very difficult to accept Hobbes's view that ultimately the sovereign state reserves the right to control speech, religious practice, the educational process, and so forth. And that may indeed be a strong reason to reject his view. But before you just give up on Hobbes, I do invite you to reflect on whether it's completely obvious that the state, even a state like the United States, doesn't at some level reserve the right to control speech, religious practice, education, and so forth. You should ask yourself before you abandon Hobbes's view on these kinds of grounds, you should ask yourself whether there's anything legally that stops the US sovereign from amending the Constitution so as to, for example, repeal the First Amendment, right? I mean, if a particular religion starts becoming ensconced among the citizenry of the United States, and citizens decide, well, we want to have an established church now, or some established religion, why can't they assemble and repeal the First Amendment and replace it with some alternative constitutional provision that establishes a national American religion? It's not obvious that the United States sovereign, a sleeping sovereign admittedly, couldn't assemble and completely transform the American Constitution so that it says something very different. Of course, we don't like that idea because we've been socialized into a kind of Western liberal democratic ideology that tells us that it would be terrible for the state to establish a national church. But you, again, should ask yourself, where do you get that ideology from? Perhaps it has something to do with the way in which you've been encouraged to accept certain kinds of beliefs in civics classes, in publicly funded schools. Maybe that actually attests to precisely what Hobbes is talking about, right? I mean, because Hobbes, of course, thinks the sovereign should control education and instruct citizens so as to accept certain basic assumptions and beliefs about how politics should go. And maybe your commitment to the standard American view that you shouldn't have a national church, that there should be a strict separation of church and state, maybe your socialization into that ideology or that view itself exemplifies precisely what Hobbes is recommending. You have likely imbibed that view from your own education, and that education has, of course, been given to you on the dime of the state itself. So you should think about that. And of course, more broadly, it's important to ask yourself the question, I mean, remember, there are lots of states around the world that do have established churches and state religions. Cambodia, England, Costa Rica, Denmark, Saudi Arabia, Iran, Israel are just a few examples. Do you really want to say that all of those states are illegitimate just because they have national churches? Hobbes, of course, is after a general theory of state legitimacy, and so he wants a theory that's going to establish the authority of all existing and stable states, and that's why he argues the way he does. But of course, it's a big cost to say that none of these countries, like, for example, Israel or Denmark, that they're illegitimate states just because they have some state religion or a national church. So think about that. A couple of outstanding issues before I end on Hobbes. You'll remember that I also raised another general worry about Hobbes on freedom, which had to do with accountability and responsibility and blame, right? And I suggested in the last lecture that because Hobbes has this rigidly deterministic picture of human action, one might worry that he can't really explain how it's fair for the state to blame people and hold criminals legally responsible for their wrongdoing. But in his chapter on excuses and extenuations, and also a couple of discussions of coercion, Hobbes gives a response to this, and I think it's worth noting that his basic argument here is one that is still accepted by many legal theorists today, who accept something like a deterministic view about human action. So I just want to say a little bit about Hobbes's argument here, because it is at least interesting. Hobbes basically says, well, let's consider two broad kinds of cases. In one kind of case, one person causes another person's death. Let's take the case of a killing or a murder. A causes B's death because A desires B's death. A has an aversion to B. A has some kind of appetite to cause B or B's family distress, right? I mean, that's one kind of case. Now imagine a different kind of case, or a different set of possible cases. Let's suppose that one person causes another person to die, not because they want them dead, but rather because, say, the killer trips accidentally and bumps into B, and B just happens to be at the top of a cliff, and because A bumps into her, B, unfortunately, herself loses her footing and falls off the cliff to her death. Or let's suppose that A was drunk or completely out of her mind at the time and had no idea what she was doing when she took action that caused B's death. Or suppose A was coerced by some third party C, into killing B under threat of intimidation. Or perhaps A is a soldier and believed that B was in fact an enemy soldier when in fact B was an innocent civilian, and by accident therefore shoots B, right? That's a different kind of case. Now what Hobbes is going to say about these two cases is interesting. He's going to say, well, in both types of cases, A's actions are causally determined, but even though that's true, we can still distinguish between the two cases because in type 1 cases, we can say that the killer's own will and appetites caused the victim's death. And in those cases, we can therefore say that they were culpable because they wanted the person to die. But in type 2 cases, we can't say that. If I just accidentally trip and throw somebody over a cliff, then I didn't kill them because I wanted them dead. And Hobbes' general strategy is to say, well, even though that's just as caused as a murder that is contemplated and committed because somebody wants the victim dead, even though it's just as caused, we can excuse these kinds of killings because there was nothing about the agent's own will or own appetites that was causally involved in the death. And that's Hobbes' basic strategy for preserving our ordinary intuitions about criminal responsibility, despite a commitment to determinism. Again, it may not work. This general strategy hasn't convinced everybody. But as I say, this is still a live approach that is adopted by many legal theorists today who are interested in the basis for criminal liability and criminal responsibility. So it's certainly worth your while thinking about it. But there is, I think, a sting in the tail that comes out of this point that Hobbes makes. Because I think it's striking that in the examples of extenuating or excusing circumstances, Hobbes includes acting under duress. Right? So he includes, in his discussion of criminal wrongdoing, as an extenuating circumstance, the fact that I kill someone but because I'm being coerced by some third party. I mean, suppose it's some gangster who can't, for whatever reason, bring him or herself to kill the victim. So instead he coerces me, threatens me with death unless I kill the victim. And Hobbes says, well, look, a person who's under duress, who's coerced in that way, they're excused from legal liability. The real source of the action was the person coercing. But if you cast your mind back to what I was talking about in the previous lecture about Hobbes' defense of slavery, I think this reveals a real problem for his view, because he, in the passages on crimes and excuses, he seems to allow duress as an excuse for wrongdoing, but in his discussion of slavery, he denies that duress would actually void a slavery contract between a conqueror and a vanquished individual, for roughly the reasons that I gave in the last lecture. But that seems to me to be deeply contradictory. Why does duress act as an excuse in the one case, but not void a slavery contract? And I think that's a real problem I think there's a real contradiction there in Hobbes' view. And when one adds in what I've mentioned already, his involvement and complicity, arguably, in the slave trade as a member of the Virginia Company, this, I think, perhaps really does suggest that there is a significant blind spot in Hobbes' comprehension of liberty. And maybe this is a sign that there's something deeply wrong with the way he's thinking about political freedom. So that's an outstanding worry that I think poses a significant problem for Hobbes and the nature of his commitment to individual freedom. All right, I am going to stop there. That's the end of lecture 6.5. I'll stop here and I'll start afresh with a shortened lecture 7 starting on Locke in the next lecture. So thanks very much for listening. See you all very, very soon.